this is, I should know this, but we have for several years, and I can't tell you what number of year this is, for several years, Truth in Accounting and the Keeley Center for Financial Services here at DePaul have sponsored this event every year. And
you okay with the mic?
yeah, I'm fine.
Okay.
Jim has a lot of it, so I think everybody can hear me. Okay.
Turn it on your microphone, they can stand there, the show is switch on.
No, it's, do you need it, Terry?
Yep, in back you need it.
I don't think it's.
It's on.
Okay, is this helping? Okay, all right, great. So, Truth in Accounting, as you know, its mission is to educate the public and help them understand government-produced financial statements that are transparent, accurate, and understandable. Thank you, Sheila. Sheila is the founder and CEO of Truth in Accounting, and is the one who is the heart and soul of this organization in terms of its mission. How many people have been to Truth in Accounting events before? Okay, good. So you liked what you heard before. Thank you for coming back. You're live in hope, die in despair. So the other question I would ask is how many people here are just interested citizens? Okay, and how many are activists in this area? Yes, we do have some of those, and I'm sure we will hear from them during the day. And finally, how many people are contributors to Truth in Accounting? Thank you very much. That's not enough. There's information on your at your table. So we'll look forward to your help on that. So we'll on with the program. Today's speaker is Jim Spiotto, and Jim is a managing director of Chapman Strategic Advisors, and they specialize in strategic initiatives on topics of interest to municipal market participants. And he's also the co-owner of and publisher of MooneyNetGuide.com, an online resource specializing in municipal-related research and information concerning state and local government. So without any, I've had my time up here. It's time for me to step aside, and the mic is now over to Jim. So,
good. Well, thank you, Mike. I really appreciate it. And after the talk, you may regret the claps. Thank you very much for coming. And I think there's no topic that is more important to all of us. When we look at the future, and we look at what, is that too loud? And we look at what is going to be the future of our state, and what will our state be able to provide essential services, not only to us, because they have for a long time done that, but to our children and to our grandchildren. As you know, or as you may know, in Chinese, there are two characters for the word crisis: danger and opportunity. You can, and probably have seen, a lot of discussion, numbers, analysis that explains the danger with regard to pension liability and underfunding. Hopefully today we'll talk a little bit about danger, but more the opportunity. What can be done, what has been done, where are we and where can we go? To start with, I think it's important, and this slide presentation will be available to you electronically. As I've said about all of the slide presentations I've done, they are the best cure for insomnia. So you'll have it if you need it. Pension started out as gratuity, a pay-as-you-go, if you can, when you have the ability to pay. In the 1900s, there was growing awareness, especially with the rise of organized labor, of the need to do something more, a promise that was more permanent, not something that could be taken away. And from that came various statutes, various contract provisions, and various constitutional provisions, making pension obligations a contractual obligation. There are 6 states or so that have it as a property right, but it's sort of a very limited property right rather than a contractual obligation per se. And this chart just sort of shows you where the breakdown between general constitutional provisions and state statutes or case law that provide those. And, so there are contractual rights by and large, and we sort of list the ones where they're not. And one of the real issues of the law is to prevent impairment. Now remember, contracts, like anything else, is an agreement between two people. One, to normally pay something, and the other to perform something for that payment. Contracts can be modified, they can be altered. We all know that if you've done any home improvement, you wish the contract that you signed up for the home improvement was the last time you did an amendment or an alteration to the price. Things change. So alterations of contracts are not uncommon. Impairment of somebody's rights at least attempts to sound like something different. And I think that's what we need to look at and talk about from both the legal and practical perspective. And the developing case law and the developing efforts in this regard, you'll see that people are trying to better hone in on what really is an impairment that should be done, and what are the modifications and changes which we in our normal commercial life or individual lives and dealing with our family enter into contracts and make changes to them all the time. The case law has developed over the years with regard to what can you do. Generally, if you want to write a labor contract that is subject to modification and change for exceptional circumstances where you can't make the payment because you can't survive as a government, you should write that into the contract. I mean, there's the Rhode Island case in which they argued and litigated recently that really makes clear that future contracts and labor negotiations are going to have some discussion of, what can we do to have more flexibility? Because if the government fails, employees' payments fail, retiree contributions to their pension fail. So it's very important to keep alive the contractual ability of the government to be able to pay, keep them alive as a government. Also, you can make changes with regard to the nature of a pension and the purpose of a pension fund to justify either strengthening it or providing successful continuance of the pension fund. Modifications generally under the law have to bear some relationship to the theory of the pension system. A governmental body just can't wake up someday and say, this really creates problems for me. And so we got other things we want to do, and so we're just not going to live up to our pension obligation. That's not a rational, appropriate, or contractually sound way of approaching the problem. There's a movement going on. We had, and probably some of you know this, I'm sure, and others you may have heard of it. There's the California rule, which a good number of the states have followed. And that rule was that once you were employed, there couldn't be any change to your contractual benefits, to your pension, unless any disadvantage was accompanied with an appropriate advantage. And therefore, once you were employed, you continued to receive your pension benefits unaltered until you retired. I'm sorry, when you retire, you continue to receive them, and there can't be any alteration of them. what happened, and they saw in California, this started to crowd out the ability to provide essential services to a lot of different cities. The obligation to pay for the pension obligation at times started out, pension payments were 25% of the salaries, and then it raised to 50%. Some of it is over 80% of the amount that you paid the salary, you have to pay into the pensions, taking that money away from governmental services. And even when the workers and the municipality were trying to work something out, they found themselves in a difficult problem over the California rule. There's now some litigation. There's 5 cases out in California there where the appellate court, it's now up before the Supreme Court, is going to make a change to that and basically say that you're entitled to a reasonable pension. And you're not entitled to the optimal calculation of that pension, but rather a calculation that gives you a reasonable pension given the facts and circumstances and the basic theory of the pension system. And hopefully we will see in the next couple of months after that's argued and ruled upon. The California rule, which started out in California and has spread to about 20-some states, has been rolled back in a good number of states. And California, I expect, given the the number of cases that have specifically ruled now on the appellate level, that the California rule is not workable and feasible, that will change. And that's sort of a coming attraction, which to us here in Illinois, where we have our Supreme Court case that basically says you can't make any change, that the contractual obligation cannot be diminished or impaired in any way, and including is the COLAs. And as you may recall from reading the newspapers, there was an effort over the last 5 to 10 years to deal with the cost of living adjustment. The cost of living adjustment, for I think most of you know, is after you retire each year, and depending upon your contract, there's generally in Illinois, for many of the workers, state workers, a 3% cost of living adjustment that compounds each year. That compounding 3% becomes a significant amount for a retiree who lives 10, 15, or 20 years. In California, those provisions have created situations where the worker within about 5 to 7 years winds up making more money retired than they did as a worker, and therefore placing the burden. Same thing works here in Illinois and elsewhere. Because of that, there are numerous cases throughout the United States. Courts generally have decided that cost of living increases could be adjusted and should be adjusted because it's a forward event, and quite candidly, the 3% cost of living adjustment, reasonable as it may have been at the time of negotiating, was not indicative of what the real cost of living was that should be adjusted. So there are many things that can be adjusted. Future benefits generally, and the trend is that they obviously can be adjusted in virtually all of the other states other than Illinois. And we'll see what happens in California with the California rule. Reductions in mandatory retirement age, obviously, because that's more of a benefit than a detriment. Reductions in hours and salary. And one of the things that is always interesting in the court with regard, we'll talk about this a little bit later, in the San Jose situation, where they had a 70% referendum in favor of changing pension benefits. And with that approval, it was appealed to the local court, and the judge, sort of following a Solomon-like approach, basically said, well, I'm not too sure about these changes without a corresponding benefit, but I agree that you can fire employees at will whenever you want. And you know, which brought everybody back to the table to renegotiate. One of the things we see in Arizona and a number of other of these situations has been that if you push the governmental body too far, what do they do? And since 2008, we have seen a reduction in the number of municipal employees. In Arizona, which has the same constitutional type provision as we do, and they had a case similar to the one in Illinois, and they basically found, for a number of reasons, somewhat different ruling, that they weren't going to allow any changes to COLA and some other provisions in pensions because of the constitutional provision that it cannot be impaired or diminished. Rather than having 630 pension fund systems like Illinois has, they have about 3 or 4, and their police and fire were for the whole state. City councils and city managers started to say, I don't think we need 4 or 5 firemen on that truck. I don't think we need 2 policemen in the squad car. And they basically proceeded to roll back employees. The first responders, being very clever and smart, recognized this was not a good trend. So what they did, and very effectively, they basically got together and worked on a constitutional amendment one time, and a change to the pension system that allowed these changes to save their jobs so that they would not lose jobs because of the pressure on essential service funding and paying their pensions. And those modifications were put into legislation that then was put into an amendment that was adopted and passed. And now the correctional workers and other public workers in Arizona are looking at doing the same thing. And so reasonable modifications can be done. Another thing to keep in mind, and this is sort of laying the groundwork for what we're going to talk about, and that is that our Supreme Court has recognized that when governments, state and local, enter into contracts, they cannot surrender their police power. As a governmental body, they are there for the health, safety, and welfare of the citizens. They are there to make sure that you have essential services at an acceptable level. And that cannot be surrendered by contract. And therefore, if a contract takes advantage, so to speak, of the government, or if the contract over-provides for the payment of a sum that is not affordable or not in the best interest of the health, safety, and welfare of the citizens, that contract can be altered. That is an exercise of the police power for a higher public purpose. Because government should not fail because of a contract that was not approved. And that a number of Supreme Court cases have said that in Puerto Rico, which obviously you read about as having financial crisis, as well as suffering from the wrath of hurricanes, they actually, in a decision in 2013, followed what the Supreme Court in other cases have done and made changes to their pension programs based upon the higher public purpose. We need to survive as a commonwealth, and we need to make changes that are reasonable and necessary for an important purpose. So we'll talk about how that really works a little bit later. As you know, just background, there are 4,000 public sector retirement funds. The underfunding, depending upon who you want to talk to, what discount rate you want to use, is between $1 trillion to $3 trillion or more. The underfunding, when you compare it to what the revenues for state and local governments are annually, which is about 3.3 trillion. You can see that's a significant number in relationship to annual revenues. Most market analysts from the municipal bond perspective think the underfunding pension problems are the key problem for credit and for the survival of local and state governments. One interesting report just came out from the Boston College Center on Retirement Research. In 2000, the top third of funded pension funds had an average funding of 110% in 2001. The middle third had 100% funded ratio, and the bottom third had 90%, and those dropped to respectively 90, 73, and 55 by 2017. Now those are averages, and averages are averages, which are not necessarily an indicator of how bad it is for certain people. Interesting that part of that drop is attributable to, obviously, if you look at the S&P 500, it lost 49.1% between March 2000 and October 2002, and again in October 2007 and March 2009, it lost in value 56.4. So investments by pension funds can create losses. That's why some states are starting to look at loss sharing. If you look at Wisconsin, which is virtually 100% fully funded in their pensions, they have a loss sharing approach that we'll put in the money, but in the administration, if there are losses, we're going to share that. It's not going to be solely on the state or local government. Obviously, that offends the notion of the defined benefit, but might be closer to the realities of dealing with this problem if the state or local government doesn't have the ability to meet and fund their pension obligations. Now, with this, I want to make clear, obviously, if you have a municipality or a state or, that has more than enough resources to pay their pension obligations, you have no problem. And there are states and there are municipalities that are in that position. And if it's a question of, I just don't want to raise taxes and I can't raise taxes without any serious consequences, you have to get realistic about performing your obligation. What we're really talking about is not an unwillingness to pay. It's not an inability to pay. Let me put it this way. We're not talking about those where there is an unwillingness to pay, because that's just a question they should pay, and that should not be an issue. What we really need to focus on for pension reform is the inability to pay, because it's a crowding out of the essential services that create people leaving. Detroit did not literally happen overnight. Obviously, they lost population, but what happened is Detroit had the highest taxes in the state. They lost population, obviously, between 1960 and 2013 when they went into bankruptcy. As they lost population, to meet their costs, they raised their taxes, and to balance their budget, they cut expenditures or reduced services. When you raise taxes and reduce services, you have what you begin with is a death spiral. People move out. Corporate and individual taxpayers move out. It happened in Bridgeport, Connecticut in 1991. You go through every municipality who's had an economic downturn, you're going to see the death spiral begin. The only way to stop it is economic development and giving the people the services that they need that attracts other people wanting to be there. And reversing the trend is no easy task, as Detroit still is working at that. So, as you know, we have an aging population. With an aging population, you're going to have a smaller percentage of the population between 18 and 64 in the next 30 to 40 years than we had before, and that means there's gonna be more burdens on the targeted area taxpayers, and it's a reason why you need to address it today, not tomorrow. Over 45 states have addressed pension reform. Most of them, it has been allowed. In 20 out of 24 recent court decisions of some final nature, the reform, be it a reduction in benefits, changes to COLA, increased employee contributions, etc., have been approved. There are 4 states where that did not happen, Oregon and Montana, where they said the proponents of the reform did not prove it was necessary. They did not prove the higher public purpose outweighed the pain and suffering to retirees and workers. The other was Arizona, which had a constitutional provision similar to Illinois, which changed it and solved it, and is in the process of doing it for others, not only the first responders, by a constitutional amendment and legislation. And so the singular one sort of left out there is Illinois in our Supreme Court decision. Now, California did reforms recently, Rhode Island's done reforms. We talked about the COLA. We did have successful pension reform, albeit at the expense of the new worker, and that's creating tier 2, which is lesser benefits for the new employees. Where reforms sometimes have occurred, they have generally been a bottom-up experience in Lexington, Kentucky, in New Orleans, in Chattanooga. The citizens in the business community led the pension reform and caused it to occur. There are interesting examples of where the community recognized we're not going to have a situation where our funding of essential services drives out people and businesses, and we want to motivate and have the best employees and the best services, and constantly in a financial bind, you're not going to get either the services or the employees at the level that you desire. So you got to work through that. The 2013 legislation, which claimed $160 billion savings over 30 years, people can debate that, but it was a step forward. The Supreme Court, in reading their opinion, they were obviously irritated that we had the income tax increase sunset. There wasn't efforts to raise taxes in their minds. They felt the legislature did not do what they should have done, and therefore they were not going to allow the pension reform that was proposed, and came down with some very strong language about pensions not being capable of being amended and altered from what was originally bargained for and achieved by the workers once they were employed. The problem with that is that it doesn't live in the reality that we live in. And the court really did not look at the police power. The court was reacting very strongly to the inaction of the legislature and the inability of sort of other situations to solve the problem. And it felt that there wasn't any good faith negotiation. Obviously, consensual resolution to any problem is good, but consensual resolution occurs when everybody feels they have something to lose and hopefully something to gain. The Supreme Court decision, as strong as it did, made the pension protection clause an unfortunate obstacle to voluntary resolution if the workers believe they have nothing to lose, because all the municipality, state or local government has to do is continue to pay. And I think the false premise of that is that governments can fail, people can move out of governments, corporations and individual taxpayers, and the situation will only get worse. Obviously, the city of Chicago actually had negotiated with labor, not through formal negotiations and arbitration, but through discussions with them, and they negotiated pension reform, which the Supreme Court knocked down because it wasn't through the formal labor arbitration process. That was, again, and clearly the legal principle there is that obviously if you negotiate employee benefits through the formal process, you should be able to make changes, but if you don't use the formal process, you shouldn't. Again, the inability to make any modification as reasonable and as appropriate and as necessary as the city of Chicago argued it was truly sort of unfortunate. The city also raised, which I think is an interesting, not to bore you with a sideline legal issue, but in 1963, we have in our Illinois development of our pension law, the legislature sets forth the pension code. It enacts it, it sets forth what the different municipalities have to pay, both state and local, and to the degree that you pay it. And the funding was sort of a mismatch. The funding with regard to, like the city of Chicago, was based on a formula of a percentage, a multiplier actually, of what they put in 2 years prior. The problem with that is the multiplier bore no relationship to the actual obligation of the pension benefits that were accruing. And so you had a defined benefit proposal in benefits to be received, funded by a fixed formula, which was more like a defined contribution. So it didn't work. And in 1963, there was a statute passed. The statute specifically said that the state and local governments were not responsible for pension underfunding or liabilities over and above what they were required by statute through this formula to pay. And so the city said, look, we paid everything the legislature told us to pay, and the statute says we shouldn't be liable for anything more. And the Supreme Court came to a sort of unique interpretation that the constitutional amendment in 1970 that said contractual pension obligations were contractual relationships that shall not be impaired or diminished, basically overruled and superseded that statute. The interesting issue there is all that the constitutional provision in 1970 really said was it was a contractual obligation. Going back to what I said in the beginning, it started out as a gratuity. People didn't want it as a gratuity because that type of charity can come and go. They wanted something that was contractual. And contracts can be amended, changed, modified. So what actually, I think the Supreme Court may have missed an opportunity to use that statute to say, yes, we have a problem here. We haven't had the funding by legislation that we were supposed to have, and by statute they're not supposed to be, that are not sustainable and affordable. And so we need to make a change. And so I think that might be something, now it sort of got ruled out in the city of Chicago case, but I think there's always been a distinction in Illinois case law between the obligation to funding. A number of cases say that the pensioners can't go to the city and say, we want you to fund this year. They as a governmental body can fund whatever they want to fund. It's up to them complying with the state statute. And so what I think is a possible interesting point here is that, and the confusion of funding with contractual obligation. And if you can't fund because it's not affordable and sustainable, is it really an impairment? There's an old case coming out of the city of Asbury Park in New Jersey during the Depression. And what the US Supreme Court said was that if a governmental body is in such financial distress that it cannot pay an obligation or a debt, it can, and this is for a higher public purpose, impair or basically eliminate that payment which it realistically has no funds to pay. And they went on to say that's not an impairment because realistically it was a paper right that had no ability to be met. And therefore there was various obligations that were specifically amended or impaired because of that. Talk to you about the San Jose case and the Arizona case and COLA. Now obviously you can use Chapter 9. You know, Chapter 9 is sort of like the universal solvent. You know, the old adage, you know, if you develop a universal solvent, what do you keep it in? You know, and it's sort of the same thing. Chapter 9 has stigma, it has cost, it has uncertainty, you know, there's a lot of downside to Chapter 9. But what appears to be clear from the case law is that in Chapter 9, pension obligations can be modified and changed. Michigan has a similar constitutional provision as Illinois. When Detroit went in, they raised the question. They said the constitutional provision, can the bankruptcy court transcend that, cannot impair or diminish? And the bankruptcy court basically said that's what bankruptcy is all about. It's the land of broken promises. And basically, you can impair it, and that was its order. In every bankruptcy case to date where it's come up, they have allowed it. Whether or not, like in Detroit, they made sufficient modification and change, that's a different issue. They made modification and change, and so you can do it. Some may argue because of the constitutional provision in Illinois, if Illinois, which presently does not allow Chapter 9 for its municipalities, were to allow it, the bankruptcy court could not impair the pension obligations. Well, that came up in Stockton and some other. Quite candidly, our Constitution provides that the federal government has the exclusive power to make bankruptcy laws. So if a state authorizes its municipalities, which it has to do to use Chapter 9, it is then preempted, which means since you authorized it, you have basically agreed to the exclusive power and to live within the parameters of that law. So as much as I think you'll hear some arguments that even if Illinois allowed Chapter 9, they couldn't undo pension obligations or impair them, I do not think that legally is going to stand. Has not in all the different, in Stockton, and San Bernardino, Jefferson County was a bankruptcy case, Chapter 9. Their pensions were fully paid, so they didn't pay anybody else, but they paid their pension, and so they didn't have that problem. Now, you can see in the materials which you'll get, we go through that. Now, if state and local governments can't file for Chapter 9, what do they do? And we've already talked about making changes for a higher public purpose as an argument for impairment. We talked about the Canerva case, just talked about healthcare benefits, which we haven't really rolled in here, but they basically said they're covered by the pension clause too, so they have the same issues. We talked about the city of Chicago. And for those of you who want to look more deeply into this police power, we cited some precedent, some arguments there, but I think you get the drift. If you look, and I'm not going to spend a lot of time, I think there's two things as you came in from Truth in Accounting, and I think those of you familiar with Truth in Accounting, they do a great job. They have a great website. They have their lab on their website, which is terrific. You can look at any state and see. They have all sorts of information. They have a newsletter that comes out every day with everything that is sort of happening in government finance. Quite candidly, getting on that list is worth filling out that blue or whatever green envelope, because getting on it, I think, is very helpful, and I think they're to be commended for doing that. I'm not going to bore you with it, but we have a lot of information here. Quite candidly, Illinois and the funding of its pension, obviously, we have not funded to the degree we should have. I mean, that's on a state level, it's truly just a matter of fact. You can't undo facts. And they're increasing it. Obviously, we quadrupled from what was in 2008 the contribution by the contribution in 2017. The contribution, of about $6 or $7 billion. I think it will be going up in the next years. However, in 2018, the outflow was $11.2 billion. So if you're contributing 7 or 8, and we're still paying about $1.5 billion a year for at least the next couple of years on the pension bonds, you're never going to catch up with that type of formula. And the $7 billion is about 24% of our general funds. And as you know, from any sense of accounting, taking 24% of your total ability to pay, in some respects, is a real pain. Remember, we've had unpaid bills. We still have some remaining unpaid bills. We're trying to figure out how to pay them. J.P. Morgan did an interesting study. They said, if you look at bond debt, if you look at the share of the defined benefit actuarially required contribution, now the actually determined contribution, the retiree health care costs, the defined contribution plan expenses, and you have a rate of return of 6%. What would you have to pay on a over a 30-year period, level payments, as a percentage of your general fund, or your state revenues, I should say, as collected? And they looked at the various states, and this is what they came up with. And you can see for Illinois, it's about 24-25% is what we're already funding, and we're going to have to pay another 25%, or about 50. I think their total calculation is 51% for 30 years of our general fund. Now, we go through all sorts of numbers, and I'm not saying this is absolutely correct, but it's directionally correct. And that's why we have to do something. You can't crowd out essential services for education, for public safety, for roads and transportation, for social services, the way this would. And if we don't do it now, it just gets bigger later on. So I mean, if you really don't like your kids and your grandchildren, keep it up. We talked, there's some more information done by various people, and I talked about Truth in Accounting and theirs, and you look at the total debt burden, I mean, quite candidly, and both for the city and the state, and, whether it's, 50,000 per taxpayer for Illinois and 36,000 per taxpayer to pay the debt for Chicago. Those are real numbers, and you sort of add them up, you don't subtract them. So it only gets bigger and bigger. Now, how do you solve it? And I'm going to give you 4 different ways to solve it. One is a prepackaged Chapter 9. Problem with Chapter 9's up to now, very expensive. $170 million, $180 million in professional fees, just by Detroit in their bankruptcy. As some municipalities have said, they're too poor to go into a Chapter 9. They can't afford it. So it is a real issue. There's a way of doing it, Chapter 9. Presently, we've had free fall Chapter 9s. We basically have said, I've had it as a municipality, I'm authorized to go in, and I'm gonna go into the Chapter 9. There have been very little planning, very little negotiating, very little, this is why I want to come out. Pre-packaged, and this is what we've done with corporations for the last 25 years, realizing how expensive bankruptcy could be. We have put together the package, and that's originally the way Chapter 9 was supposed to work. The municipality puts together the package, negotiates, and gives disclosure information to its creditors, gets a vote, gets at least one accepting class that is impaired, and then goes into bankruptcy, and within a 3 to 4 month period can get it all done. That is sort of the way to go, and without boring you with the technicalities, it's doable. Rather than waiting to the last minute, then filing Chapter 9, start a year or two earlier and solve the problem. Another is to create a federal bankruptcy court for insolvent public pension funds. And by that, the federal government has the power to create a bankruptcy. And this is not to take away from the worker. Let me tell you where I'm coming from. The government should pay as much as it can on the pension obligations without turning over the government, without putting a cloud over the future. And quite candidly, I believe that any true pension reform should be tied to economic development, infrastructure improvements, and attracting new businesses. Now, paying as much as you can doesn't mean that you mortgage the future. It means that you be rational about it and fair about it. And with regard to a federal court, we can create a federal bankruptcy court, which would be special to pension funds, because quite candidly, it's the pension fund that's truly insolvent, not the government. And it can then determine what is sustainable and affordable. You put in staff and judges who are familiar with government finance and accounting and pensions and budgets. It will require a long-term 5, 10 or more year projected budget of the municipality. It would hardwire payments of pensions so that the actually determined contribution, once the pension has been determined to be sustainable and affordable, would be made, so you're hopefully not going to revisit it again. Another way of doing it is what we call government oversight, refinance, and debt adjustment, which is a way in which the state can create for its municipalities, and possibly try for the state itself, to set up a commission, which is quasi-judicial, that would sit first to encourage consensual resolution through arbitration and negotiation, through mediation. They'd have special masters. There'd be at least 3 commissioners, one to deal with mediation and consensual resolution, another to deal with basically full disclosure of financial information, and another to basically be the determinations made on a quasi-judicial body basis. A similar approach to this was in HB 2575 that the Civic Federation supported. There was a bill introduced in the House in 2017. The last is model guidelines for a state constitutional amendment or legislation that basically provides for pension funding policy. And what that is, we have state and local governments are all required by the Constitution as far as the state statutes as far as local governments to have balanced budgets. As we've talked about, that's sort of honored in strange ways. Some people have interpreted the word expenditure to mean I don't count I balance it by saying, if I don't pay the obligation, I haven't made an expenditure, so I basically build up bills and obligations without paying them and claim it's a balanced budget, because I don't have enough money to pay. I mean, it's sort of lunacy. So, what does that mean? That means that you first balance the budget, you determine what is sustainable and affordable in the balancing the budget process. You determine what you can pay vis-a-vis the pensions. And quite candidly, a lot of this, as we know from past reorganizations, restructurings, going back to the railroads, your pension obligation can be, here is a base floor, and here's more that you can earn as we, working together, create economic development and create a high tide of economic stimulus that raises the boats. If you attract more taxpayers by bringing in more business and employing more people, you will raise more tax revenues and have an ability to pay more. And so there should be some flexibility in what you provide. Likewise, if it goes the other way, you need flexibility to make changes. We have in the guidelines, and I'll show you very quickly in conclusion, the various steps. And you can do that as a constitutional amendment, or you can do it as a legislative policy. As a legislative policy, there will be specific findings that you are paying as much as you can, that you are not impairing anything that you have the ability to pay, you are only impairing that which you don't really have the ability to pay, and you have balanced the harm to the retirees and the harm to the taxpayers, citizens, and municipality. That as part of this process, if there is any, and you would first start only with future benefits, and you would not be taking away any current earned benefits. And if you ever had to get to vested current earned benefits, there'd have to be a court determination that you can do that under the higher public purpose, so that you're trying to protect, from a due process standpoint, everyone concerned. And this goes through it here. You pay the annual, the actuarially determined contribution, and that would be part of the budget that would be balanced, so there'd be no more pension holidays. And quite candidly, presently, the outflow from Illinois state pensions is $11.2 billion. In 18 years, it'll be almost $22 billion. So, unless we come up with a solution, the ramp doesn't go this way or that way, it goes that way. So I think it's sort of something to keep in mind. You want to make sure that you have reasonable and necessary modification as permitted, it's fully funded, and you can go through the rest of it, but one of the determinations they make is a governmental emergency. If you don't do this, the government is going to fail. You won't provide the essential services at an acceptable level. The modifications are necessary for the government to be able to continue on consistent with its obligation to provide essential services at an acceptable level. And just in conclusion, the answer should never be that the needed pension reforms have failed or appeared impossible, so the government itself fails and everybody is worse off. I mean, we have the ability to address it, to pay as much as can be reasonably affordably paid, and at the same time, make sure we lock in those balanced budget principles, economic development principles, and other things necessary to bring back and create the high tide that raises the boats.
Jim. I think after that feel-good session, I think our audiences here will have a lot of questions, particularly in terms of what you think is likely to happen. so we'll open it up to the audience here. Terry, I know you have a question.
Yeah, I just want to, over the years we've discussed this, I just want to get the basic facts. You told me that a state, there's no law for states to go bankrupt because they're a sovereign taxing
Right.
body. And that cities and municipalities can undergo Chapter 9, but I think earlier today you said Illinois doesn't allow its municipalities, did I
Right.
read correctly?
Right.
To file for Chapter 9. Well, first question is, what would be required? You know, all these things seem workable. I know at Bankruptcy came up with a solution that's, you two talk a lot, and it involves compromise on all sides. But given the Supreme Court legislation and the requirement that you either have to have a constitutional amendment to adjust this kind of formula, or go to court to prove that it would diminish the powers to provide the basic higher public purpose, or that you have to get some kind of an amendment to get this state to allow municipalities to go bankrupt. What's required to actually do something in the practical sense? Not that it couldn't be done, but we have a legislature that let us go without a budget for 3 years.
Well,
So,
there
can
are,
you fix this?
yeah, thank you, Terry. There are two bills pending, haven't come out of committee to allow municipalities to file.
Yeah, but would Mike Madigan ever let those come
That's
out?
the question.
Well, you know,
Thanks, Sheila.
as I mentioned, you know, as I mentioned before, just like Chattanooga, New Orleans, and Lexington, Kentucky, I think it starts at the bottom up. As Trotsky said, it takes 2% to create a revolution. And I think we need to find that 2% in a reasonable way to sort of say, we have to fix it now. If they don't allow it, you know, quite candidly, between 2008 and 2015, 2016, the net migration from Illinois was a negative 5% domestic. And we had births and, you know, some immigration that changed it. And we were second only to New York, which was 5.2% negative. And, you know, that's not the way to grow. Our population growth since 2000 is like 2.9%. Texas, it was 40. The average in the United States is like, I think 15, 16. So, I mean, we are at a crossroads, I think, that if we don't do this, and, you know, maybe I travel in the wrong circles, but I think a lot of you have heard somebody you know say, gee, I'm moving here or there. That doesn't mean they're not gonna come back to Illinois and enjoy the wonderful things that we have here, but they're not gonna be a tax resident of Illinois anymore. And all that does is increase the burden on everybody else. So I think it's really important that it gets addressed. And that's part of what I think we all have to work together on, is how do we get everybody together to get it done. Yes?
There are way more taxpayers than there are public employees. Why, after the Supreme Court ruling, I'm not aware of a credible movement, politically or grassroots, to amend the Constitution? Why?
I missed the last part.
Why isn't there a critical?
Why hasn't there been an effort
I gotta believe if there were
amend the Constitution?
a amendment on the ballot tomorrow, it would pass.
Well, to amend the Constitution, you either need a constitutional amendment, this is in the paper, you know, the Constitutional Convention, which we every so periodically have a choice of doing and it's up again, I think, 2018, we're in 2018, 2020. Or you can have specific legislation where 3/5 of both houses approve it, and you get a majority of the electorate to approve the specific amendment. I think, like every journey, it starts with the first step, and I think people have to honestly start discussing with each other what type of constitutional amendment will work that we need to help bring about a successful resolution of this. And another way of doing it is have the state really balance the budget do those things that I said, the principles of the constitutional amendment, balance the budget, make the changes, and then take it up to the Supreme Court. You know, this is sort of test the metal, but take it to the Supreme Court and said, here's the US Supreme Court precedents. Either the government fails, or we make what we believe with the legislative determinations, these reasonable changes. And remember, when Aristotle talked about virtue, he basically said it was nothing in excess, virtue is in the middle. And so, you know, quite candidly, those compromises should be found there too.
Jim, in the four potential solutions, it would appear to me that three of them, this gets to the difficulty, three of them involve basically an imposed solution that I'm assuming includes a cram down provision of some kind. Am I missing something?
Well, you know, obviously, words have meanings. We try not to use the word cram down. Adjustment sounds good. And quite candidly, it shouldn't be a cram down. It should be, we're gonna pay as much as we can without having the government fail, and enough left over to stimulate the economy so that we can possibly pay more in the future.
Okay. I'll use that word.
Has any government ever
No,
failed?
yes.
State government?
Have any, what?
Has any state government ever failed?
In the United States, no. I mean, no, with the exception of Arkansas in 1933, which immediately refinanced it, no state has failed to pay their general obligation debt since the Civil War, shortly after the Civil War. So, I mean, we have not, I mean, we were, just, the one lesson, some of you already know this probably. When, after the Revolutionary War, there was a significant debt accumulated by the various states. And a lot of the states did not want to pay the debt off, the Revolutionary War debt off, because originally they borrowed the money from markets in Europe, especially in London. And some sharp people in New York bought them at a discount, and they didn't want their good tax dollars paying 100 cents to somebody who bought it at a low discount. And Washington and Hamilton came together and said, look, if we're going to be a nation that survives and can live in the world, we need to have financial credibility. And they had the federal government assume the Revolutionary War debt. And you know, there were some states like New York and Massachusetts that had very large debt. Maryland and Virginia had basically paid off their debt. So they said, okay, if you do that, what are you going to do for us? And that's why Washington, D.C. is where it is. They moved the capital from Philadelphia to Washington, D.C.
Jim?
Yes.
Jim?
Yes.
It's about over here.
Okay. And I don't want to be unfair to the rest of the, you know. Yeah.
Well, I just thought, you know, instead of asking this afterwards for my story, obviously the effort to get a constitutional amendment on the ballot is going to heat up, I'm guessing. And the unions say that it won't pass constitutional muster. Can you lay out what you think would? Could we still not impair already accrued benefits or the benefits of retirees? You know, what is your?
You start with not. It all is a matter of degree, how much you have to do. You start with future benefits, but you have to make sure that you have a balanced budget and that it's sustainable and affordable for a long period of time. And the one thing that I think will bring people together, this is not a game of we, they, this is a game of us, that if we don't do this, you know, we will be like Arizona, where people will start laying off workers. Governments will have less revenue. There will be less to pay workers and to pay pensioners, and it's only worse for everybody. This is to find the sort of Goldilocks point, you know, where it's not too hot, not too cold, sort of just right. Everybody maybe doesn't get everything they want, but you get something that's going to work. We solve the problem, and then we hopefully strive thereafter. What I'm going to do is go this way because I know I'm missing people. And I'm, yes.
I hope this is a simple question. But if we have a state constitution that recognizes this, that recognizes pensions as an enforceable contract, is that an individual right, or is that a right that can be negotiated away in collective bargaining? For example, if a bargaining unit reaches a deal, can an individual member say, I don't wanna give up that right, I'm suing as an individual?
There's a footnote in the Supreme Court decision that makes it sound as if it's an individual right. These rights have been negotiated in a collective bargaining mechanism, and technically, there's an argument that if it's negotiated that way, it should be able to be changed that way. Again, the higher public purpose argument says, taking all that into consideration, we need to do it to help save the government, and that may be the winning one. Yes? Yes?
Yes, so would you agree that an unfunded pension liability is the equivalent of debt?
Yes.
If it is, in the Illinois Constitution that I read some time ago, it treats and it's certainly a long-term obligation because it's the present value of all these obligations going on in the future. So in the Illinois Constitution, there's a stricter regimen with respect to the incurrence of debt. And is there an area here that could be pursued that these unfunded liabilities in fact are debt and they haven't been properly issued because they are debt?
Well, that's a very interesting argument. And there's some nuances to it. Actually, that argument was made in New Jersey, where they, to help solve their problem, gave a note for $7 billion to their pension fund, and did not go through the procedure of incurring debt or for issuance of that note. And the Supreme Court of New Jersey, which helped solve some of their pension problems, declared it unconstitutional and wiped it out. There are some provisions about public debt that have certain provisions. When I say it's debt in the sense of a liability owed. And clearly, I think we have, if we were honest with ourselves, how could we have promised what we promised with the revenues that we had and the expenditures that we had, with an obligation to balance the budget each year? And I don't disagree with what you say. There are some people who have tried to make the argument elsewhere. If you're a corporation and you act outside your corporate powers, it's an ultra vires act that gets voided. And some people have said, can you make that argument with regard to grants by the legislature that exceed a balanced budget and exceed the ability to pay? That gets into political, social debates. That's why I always like to talk about the higher public purpose and balancing the budget, which gets you to the same place. But if we don't solve the problem, there are all sorts of arguments, because the creativity of people are unlimited, and especially among our legal profession. And so, you don't know what they might come up with. So I think it's really important to address it, but you're right. That has come up before, and it is an issue. Did I miss? I don't want to miss anything. Yes.
You mentioned the two-tier new pension system for new entrants. Is that universal across all 630 plans that you mentioned?
No, that's for the state of Illinois.
Just the state.
Some have. Yes.
Correction, tier 2 exists for all downstate police and fire.
Okay.
So some portion of the 630 have two-tier, but not all.
Yeah, for police and fire, but municipal workers and others, there are others that don't. Yeah, did I miss any? Okay, when we go here.
how do we, part of this is dependent upon full accrual, to use an accounting term, comes naturally to me, I'm an accountant. Reporting and budgeting, as well as modification of some of the terminology that's written into our balanced budget thing. So our balanced budget nowhere discusses revenue. It discusses funds available, which means if you can go out and steal it from somebody, it's available. If you can't, it's not available. And you have the expenditure problem, you've incurred something you don't have to pay now, it's not an expenditure, because of the definition. The same problem with debt. Debt is defined as a certain type of security, not all obligations. How do we get full accrual accounting
Well, I agree.
established for reporting and budgeting?
Jim, I would just add to that, is there a way to change current law that says funds available equal, and then expenditures equal?
Yes, I mean,
Fix it that way.
quite candidly, one of the fixes that is in this principles of constitutional amendment is basically, because in there, it basically talks about balancing it on basically an accrual basis, liabilities versus.
But could you do that legislatively right now instead of having to do it constitutionally?
Yeah, they can do it as a funding, as a funding policy, or as a pension funding policy. And I agree with you, an accrual basis solves a lot of issues.
Just to, I think you left out one step which complicates the political side of it, and that is that, as I understand the case law, what initially translated the gratuitous pensions into contractual pensions were employee contributions. And when the employees started making contributions, then it became a contract. And in point of fact, the Constitution really didn't change that much, because in 1967, in the judicial pensions, the Supreme Court used the fact that the judges had made contributions to their pension plans to, in effect, create a contractual obligation anyway. And because of that, I think we may waste a little too much time talking about the constitutional change rather than the practical change. If the Supreme Court, as it's kind of hinted at, and you as well discussed, that the impairment of contract clauses always were the obligation of the contract, but not the payment of the contract. And to the best of my knowledge, we don't yet have a case, certainly not in Illinois and not really anywhere in the country that I'm aware of, that says that the judicial branch can issue a mandamus against the legislature to appropriate money. So it's the absence of the payment, or the ability to compel payment, is the bargaining chip on this Arizona model, and I think that's the way it really has got to work out. But it takes political courage to do that.
Right, there is, in the Slodowski and some other cases, if they run out of money, the court has sort of left the Illinois Supreme Court the door open to revisit whether they can require the municipality or the state to provide those funds.
Yeah,
Okay.
but again, I don't know how you get
Right.
the higher principle,
Right.
got separation of powers, at least we
Right.
think we do.
Right. Yes.
There's a south suburb, I think it's Calumet City, that was choosing between paying their pensions and paying for police and fire. And the Supreme Court ruled against them, and they had to make the pension payment.
Yep.
They therefore laid off 25% of the police and firemen. And in those areas, in those surrounding communities, the real estate taxes are so high, they're at least double what the Chicago rates are, which are the second highest in the country. And you're seeing everybody just leave. Aren't you gonna more likely end up with a Detroit situation where everybody's gone? They can't find anybody to tax, and the pensions keep rolling because the Supreme Court's saying, you know, the pensions are sacrosanct, and you're gonna end up with like a wasteland.
Well, you know, I mean, you're not wrong in the perception. I mean, the one thing, the difference between Detroit and the Chicago metropolitan area is the GDP of the Chicago metropolitan area is significantly higher. And, you know.
We know, but once cancer starts, like, you're seeing that whole area turn into cancer. You know, one thing that I see legislatively coming is they wanna, more than increase your taxes on income by over 100% after increasing it by 67%. That's not a recipe to attract anybody.
Right, no, I mean, you're right, and that's why something has to be done now. I mean, there is sort of when you go out and talk to people, and maybe some of you have had the same conversation, people say, well, you know, isn't this something we can see, let's let it go for a while? And that's how we got to where we are. You know, I mean, if we don't address it now, exactly what you're saying is happening in some of the southern suburbs there, you know, could become a model for elsewhere.
We own downtown buildings, and right now, the average increase in assessed values in our downtown buildings is over 100%. That's on top of anticipating an increase in our income taxes by more than 100%. So I see no political interest in, well, it's not just management.
The whole state's hired him, that's not part of the problem.
It's going worse at a rapid rate. I mean, everywhere you turn, it's more taxes. I haven't seen places where they're saying, let's figure out how to attract businesses. They're saying, how do we raise taxes?
Well, I mean, as I said, I do think economic development is key to any long-term solution.
Tax increases aren't the way to
No, tax,
economic development.
well, and if you know, I mean, and you know, that's, right, that's part of the death spiral. I mean, you're absolutely right, it's part of the death spiral. Once you start raising taxes, reducing services, you know, you gotta break that chain and you gotta solve it. That's why something has to be done.
Jim, we've been live streaming this on Facebook, and we actually have a question from a Facebook fan, the modern age. Myra asked, how much longer is it before Illinois' debt is downgraded even further and declared junk status?
I mean, I think it's impossible to sort of predict that, but it's a question of how far do you go off the cliff before you go into free fall. And I think, you know, we have an opportunity. I think there are still economic factors that are strong. I understand what you're saying, but I still think there's a solution possible, you know, compared to others. But I think it's something that people have to work on more now rather than later, and I think that's the thing.
Jim, just I'm wondering how much this whole conversation changes if Congress really does come up with a bailout of, like, the Central States Pension Fund, which is actively being considered. Because then I'm assuming that if that happens to any significant degree, that it just changes the whole dynamic of people coming together with a consensual solution to this.
Yeah, I mean, it's an interesting issue. I mean, I know from having dealt with Congress on Puerto Rico, they're sort of allergic to B words. You know, so I don't think, but I mean, that will become an issue if it happens. I don't want to short anybody. Yeah, Bob.
Well, ERISA came into being because Washington agreed that they had to deal with the pension system overall in the corporate sector. Could it be that we have the same situation evolving as a result of all the breakthroughs in healthcare and extension? Talk to Peter Thiel and other people who are saying that within the next 10 years we're going to expand the average lifespan to 125, something like that. These are serious people, and breakthroughs are coming all the time. If the actuarial profession get together and say, if some of these things happen, then we're going to have to change for everything, all the pension plans we're going to have. And if something like that happens, then the solution to all of that would have to come to Washington. And set of mendicants at the door. Is that a possibility?
Well, you know, I mean, I think we have to be careful thinking of Washington as a deus ex machina. Yes, I don't want to short any, yes.
Jim, obviously this problem with the pension funds has been brewing for a long, long time, going back as 1950s or earlier. And so obviously we all agree that we have to do something right now. But the question is, do we need to, now the legislature has said, well, we need to get this fixed, or say get to 90% by 2055, I think the current limit is. But what is where does the 2055 and the 90% both seem like kind of arbitrary numbers to me? And what they do, unfortunately, is compel the slope of the ramp to be fairly steep, so that we can get to the 90% by 2055. And as your statistics showed, I mean, if we get in the 70s, we're probably right in the range of what's average right now. So couldn't you say that we could not fix, but alleviate the problem a little bit by extending it for a longer period of time, given that it took 50, 60 years or more to get where we are, and then we don't really need to be at 90%, we could be at 70% and still be function perfectly as far as the pensioners are concerned.
You know, I mean, I think those are all the sort of the math problems that when you come up with a solution, what's the best way of dealing with it? And I think, you know, whatever people can work out, negotiate, the one thing that you know, you have to keep flexibility just in case it doesn't work. You know, so I mean,
Can I address that question
Sure.
briefly? One thing that people don't frequently understand about the liability is that's not the amount you're gonna pay. Today's liability is somewhere between 1/4 and 1/10 what you're gonna pay. So every year it accretes, rises by the discount rate used, which is now 7%. So every 10 years, Rule 72, the math pass, it doubles. Over the lifetime of existing retirees, it will double. Over the lifetime of existing employees, it will double 4 or 5 times. So if you're much below 100%, you're asking for a disaster, you're just picking the timing.
One more question.
One more question, yeah.
Is there any citizens group or other organization that might realistically be prevailed upon or take that upon themselves to sponsor, like a petition drive for a constitutional amendment, like we had in the past, the efforts to have that redistricting anti-gerrymandering or amendment?
I mean, I think people talk about it, but certainly that's one of the things that are needed. And I don't think it's a group, I think it is groups. The reason why I mentioned, it kept on a couple of times, New Orleans and Chattanooga and Lexington, because a number of business concerns, Chamber of Commerce, everybody came together and it was a hue and cry. And they changed what otherwise possibly wouldn't have been changed.
Jim, thank you very much.
Thank you.
For at least putting out some ideas on possible solutions. We know this is tough. Now, Jim will be, please join us for